everybody, welcome back. I hope you got a few minutes of outside time, or at least screen-free time during that break. Before we welcome Jamie Hopkins, our next speaker, we have another quick poll for you. Pull this up. Because we're nosy, where are you working from today? Um, Home office, actual office, your couch?
Like this is Couch Command Center. Oh, we got a few of those. That's good. I think it's crazy that probably 5 years ago, this would have been like 100 to 0
Mm-hmm.
of people in the actual office versus home office.
Wow, there's a lot more people working from an actual office than I would have expected.
If you can't tell, Alana and I are working from home. So that is more.
Absolutely.
Let's see. Okay, actual office beat out home office.
I applaud the 3% of you working from the couch.
Yes.
Incredible. I like to
I'm
work from the
glad
couch
to
on
hear it.
Fridays just to shake things up. All right. I would like to introduce our next speaker. Jamie Hopkins is the Chief Wealth Officer for Bryn Mawr Trust and the CEO of Bryn Mawr Capital Management. He has extensive wealth management experience, bringing innovative thinking, transformative leadership, and a strong reputation for fostering client relationships. He oversees the private wealth management group's financial advice strategies and growth initiatives, along with leading the institutional and personal trust businesses. Jamie graduated from Temple University School of Law, where he received his Master of Laws, and Villanova University School of Law, where he earned his Juris Doctorate. Jamie also earned a master's degree in financial planning from the American College of Financial Services and a master's degree in business administration from Villanova University. A Wall Street Journal bestselling author, educator, and executive speaker, Jamie serves on numerous advisory boards around the financial services industry and formerly is a national trustee member of the National Association of Insurance and Financial Advisors. Jamie is also the founder and president of the 501c3 nonprofit FinServe Foundation and was recognized as the 2021 RIA Thought Leader of the Year by wealthmanagement.com and is in the top 10 of Investopedia 100 Top Financial Advisors for 2023. Welcome, Jamie. We are so happy to have you join us here today.
Yeah, well, that's a long bio. That's like the whole presentation.
You had to
Read
tell
It's
it.
all of
impressive.
your accomplishments in under 30 seconds. Had to get them all in.
Well, thank you everyone for having me on, and I will try to my best on sharing here in the second too. But yeah, just want to thank Halispa and everyone else for joining us. So yeah, today should be fun. I've got a couple different things we're gonna try to get through here. So it looks like part one is up, so that's good. Like partially there, so good to go. All right. Well, thanks everyone. I'm going to talk through, I think I've got 6 or 7 different kind of estate planning related topics here that I'll touch on the tax world. The headline one of this is usually about this digital estate planning part, and Afterlife in the cloud. But I did broaden the whole presentation, I think, for this audience and narrowed that part down. So should be some fun topics here to cover today. So I'm going to take this angle. Although when I kept working on it last night and I kept thinking like estate tax in my head, but it's like estate and tax planning today, not estate tax planning for the most part. So how does our estate planning, this end of life conversation, really intersect with our tax and our financial planning? Because often some of these topics that you'll see on here, we spend a lot of time on the front end of them, HSAs and 529s, and how are we going to have this conversation with our clients about saving in them? But the unwinding of some of these can be super complex. IRAs, we tend to get into it more just because of RMDs, right? And what happens when these pass over. So we're going to walk through a handful of these today, hopefully leaving you with a good number of tips or different ways to think about these conversations with clients moving forward. Definitely things that in our business we're dealing with on a pretty constant basis, and some of these you might have heard before. Hopefully, I'll add a little bit of a different spin or conversation point to them. So, like most good presentations, right, we want to frame up the conversation a little bit here to get started. So, as part of my bio, I am an attorney by trade. Kind of started off in that estate planning world. So, I want to talk through just some of these things out there. This one I thought was, a very interesting slide out there. This actually came from some original research we ran last year at Bryn Mawr Trust. And this was just looking at, how many people have different things in place today. As a lot of you probably know, this estate planning fintech from, all these great solutions out there is continuing to grow. It's kind of to me, the next big real demand center here. And shockingly to me, I was really, really shocked by how many clients out there did not have an estate plan in place while still working with a financial advisor. It does not shock me on the other side, like how many of the national population has an estate plan in place, 32%. I've seen some other numbers saying as low as 22%. So I think that's a fair range out there. Now, technically, everybody's got a plan in place. It's just not a good one, right? There is a default plan that sits out there if you do nothing, and your estate will pass through probate and other mechanisms. But I was pretty shocked that actually, interestingly enough, when you pulled out the high net worth people and when you looked at advisors on a national representative stage, it was actually lower than the average person suggesting they had a plan. There's actually other research that has shown this too. I think really what's happening here is people with advisors are understanding the features of it that they need more. So as they get educated, they realize that they don't actually have all the features of a good estate plan or will in place, while those that are not being educated on it are thinking that they're covered here, but really aren't, because it's hard to explain it otherwise. But it's not an uncommon finding here in this space. So very, very interesting. So what does that tell me? Even on the best side, a lot of our clients still do not have estate plans in place. This was a 10-step process that I came up with, back when I was doing estate planning work. And I really haven't changed it much since then because it's kind of a broad-based piece. But I put this together actually while I was going through the CFP curriculum and doing estate planning work. And so you kind of see this melding of the financial into a more classic, probably 6-step estate planning process. So I'll just read through these. We're not going to spend a lot of time on this one today, but I still view estate planning as part of the financial plan. So understanding the goals of the client. What are we trying to achieve? Because all these different tactics, we're talking about CRUTs and CRATs later on, they're only useful if I know what the client wants. Just like all of you every day. If we don't know what the client wants, like the CRATs and CRUTs aren't useful in a vacuum. They're only useful to accomplish a specific outcome, which is typically a split interest gift between a family member, ourselves, and a charity. I have this one is probably the one that I get as much pushback as anything is involving the family early on. Well, for about a third of households in the United States, when they pass away, they essentially have no real estate of value. So to me, the estate planning portion is less so about dollars and numbers, but more about leaving your family in a good spot, taking care of the people you love, and not leaving them headaches. That's a big part of what we do. So I actually have a big argument that we should involve family, loved ones, friends, the people who are going to be involved in this estate planning process as early as possible. For some people, there isn't anybody to involve. That's okay, but that's still the right amount of involvement in figuring that out. So understanding the finances, review housing and care alternatives so we can live a good end of life, reviewing the current plan, because as I said, everybody has a current estate plan. It's just not a good one. Establishing these documents, our will, trust, power of attorney, healthcare power of attorney, implementing the plan, communicating the plan out to those that need to know, which sometimes can be a very small group. Distributing documents to the people who need documents. Could it be the hospital, your attorney, your financial advisor, and then updating this over time. So I have this slide too, and I mentioned this already, but we want to prepare for a good end of life. All of you probably have this, like, hey, don't we want to have a good retirement and planning for a good life? But often we stop short of this, like, let's plan for a good end of life. Like, what happens, right, when finality becomes reality, the end of our life? I like to talk about it too, as we probably have all heard this before, but the, go years of retirement, the slow go years, the no go years. And then I always say there's something after that, the final act. And the final act is when this finality becomes reality. And not only should we be planning for a good retirement, but we should be planning for a good end of all of this too. So we're leaving the people we care about without headaches, that we're leaving them with peace of mind and a way to enjoy and celebrate our lives, not a complicated mess where nobody can find any of our stuff and documents that haven't been updated in 30 years. We want to leave people when they're struggling about our loss in the best possible place we can leave them. So these are just a bunch of different things that I say, hey, we should be thinking about these things when we're having an estate plan about children, control of assets, right? Privacy can really matter to some people. The cost of this, how do we protect assets and expenses and taxes and put something together that really matches up with what the client is trying to get to? Then we have a lot of mechanisms in which we can get here. And none of these, right, are really like always required, actually, even though I say mandatory. Most people need a will. Powers of attorney, it says mandatory. I think these are really important. And I think healthcare directors are really important if you have a complete estate plan in place. However, there are still people that say, I don't really want these. It's not important to me. Fine. I still believe it's best practice to have these in place. And trust, it really is an optional thing. It has to fit your outcomes and goals. Now, for most of our high net worth clients, are revocable trusts or irrevocable trusts very useful? Yes. Are they mandatory? No, not really. They can get by a lot of times, especially with small estates, using beneficiary designations, using a small probate court procedure. Not real expensive, pretty fast, and depending even by your county, can be pretty cost effective too. So a lot of tools at our disposal. These are just some of them, right? Many, many more. Now, when we're looking at our clients, a question that I get often is like, how often should we be reviewing our estate plan? Well, hopefully it's our last will and testament, which means it's final. Now, it's not final in the sense that nothing will change, but hopefully it's actually built to last the course of time, that it's not something we really should be reviewing and updating every year. I think if you are doing that, something is wrong. Our goals aren't settled, right? The plan wasn't in a good spot. There was a famous writer who passed away a couple years ago, and I think he had 87 codicils attached to his will. What that tells me is like there was there was a lot going on there. Probably the goals and outcomes were not really well defined, and just constantly kept making changes. A bit of a mess. But is somebody born? Does somebody pass away? Does somebody get sick? Do we inherit money? Do we lose money? Do we start a company? Does something go wrong with our health? Do the tax laws change like they will be again? Those are the big drivers when we should stop, pause, go back and look at things. Obviously the one big beautiful bill, that's one that could cause people to say, you know what? Are things different enough after this that I need to update some of my estate planning? This isn't as monumental in the sense of estate planning changes as some previous bills and suggestions have been, but still, it is a good time to pause and look at that. So I'm going to get now to kind of our first planning topic here. And this is improper ownership of assets. And it's going to lead us into the next conversation about digital estate planning. Also, this to me is in order, one of the reasons I put it up here at the top. I still believe from looking at estate plannings, dealing with them, looking at plans that come in through with advisors, probably the single biggest issue outside of just general estate planning and awareness is improper ownership of assets. Because what happens in relationships in life, right? We own assets, we get married, we get divorced, we have kids, somebody gifts us something, we start a company, it grows. All of a sudden, it's worth a lot more money than we thought it was going to be. And the titling of these assets and ownership structures is often a little bit wonkier. And for a lot of advisors, this is something you can understand because sometimes you started a business as you and you set up your own shop and you're putting a lot of stuff in your own name. And all of a sudden you realize, well, actually, this needs to be in the company's name. And all of a sudden you had employees and it kept growing. And all of a sudden it was worth a lot of money. And how was this thing owned? Was it set up in the right corporate structure? And this gets really, really challenging, especially for small business owners. So I'm going to give a couple examples here of ones to watch out for. So it doesn't always mean that these are improper, but they're kind of like triggers, right? Things we should be looking at. So one spouse owns all the property in the relationship. Are there times in which that makes sense? Absolutely, right? There are times where that is by design, not by default. But it also occurs sometimes because one spouse had more of the assets before they got married. One spouse divested some of theirs. They just didn't think about it. They bought the house before they met. Now, in certain states, right, divorce always complicates this with people. And they said, well, you get divorced, it splits up anyway. That is true. Death is not the same as divorce under state law. So a lot of people think we're married, we're going to split up if I get divorced. That is a mindset that carries over to the estate planning world that is very detrimental and inaccurate. In the estate planning world, you can pass over what you own. That's the general rule. So if you own all the assets, you die, it goes into your estate. That is the general rule of thumb out there. Now, there's a million different caveats to that, being that most estate planning is done at the state level. So it depends, what state are we in? What are those state transfer, probate, succession rules? But it is something to watch out for. Uncoordinated beneficiary designations. We're going to talk about this one here in a second, but not updating those, putting minors as the direct beneficiaries can be an issue. I have that down here at the bottom too. But updating beneficiary designations, that's a super important one. It is one that in the financial service world, as advisors, we tend to do a little better on because these are products that we're familiar with. Ownership structures we are familiar with, from IRAs to 401ks to life insurance. We are a little bit better at following up on some of these. Failure to fund a trust is a big one, occurs all the time. Somebody goes out, they set up their estate plan, they set up a revocable trust, they're supposed to go title the property in there, never happens. Unfunded trust causes issues later on when they think those assets have been titled in there and never were. So that's actually something in the estate process that occurs a lot, is a really big issue, and continues to plague kind of proper planning. Minors as joint owners can be an issue. I think anytime you're dealing with minors as potential beneficiaries or inheritors, we just have to be really careful about this. Like, how are they going to own this? How are they going to manage it? And sometimes being careful about like picking a guardian that's one person, and picking, the manager or the fiduciary over the assets is a different person. How well will these coordinate? Or vice versa, where everything is one person. How well are they going to manage these assets for these kids? Are they going to have a lot of self-dealing, which you see in court case after court case, where, a brother or sister took over the kids and the money and spent it on a lot of inappropriate things, but without real restrictions there, without the right structure, that can happen. So incorrect real estate titling, again, especially in the spousal world, occurs a lot, where one spouse, they get remarried, they don't retitle things. Assets could pass to the children of the first spouse, and all of a sudden, the new spouse is kind of left without a home. That is a scary thing that does occur. Assets directly to special needs, or beneficiary with special needs. Again, how do we want to structure special needs trusts and transfers here? And then business assets in the owner's name, not the business itself. That's a very common one. In the RIA world, as part of an acquisition that I was working on one time, we ran into this issue where actually some of the assets of the RIA business owner was actually held in the owner's name. And we were having trouble with that. It did get resolved, but we were having trouble with that during the transformation of the business, because when we were going to them, they said, well, that wasn't sold. It's actually not in the name of the business. It was under the original owner's name. Ones to watch out here for, like websites, right? Did you set up the website under your own personal account or under a company account? And if that were to happen and you were to pass away, that asset is not an asset of the business. And you'll see things like that pop up. So when you're thinking about your business and protecting its value, making sure that emails, websites, all of the contracts and ownership are in the business ownership, not in the owner's name. So this one is super important in the kind of improper ownership of assets and coordinated beneficiary designations. And I like to point this one out, although a lot of you probably know this already, but it is one that, isn't super common every day that we're dealing with. So it's always good to highlight these ones. So when we're doing beneficiary reviews, watch out for these ex-spouse situations for federally designed benefits. So at the state level, like an IRA or life insurance that you just go out and buy, most states say, hey, look, 37 states say, we will wipe out ex-spouses that were clearly meant to be left out of this account. So you have your IRA, you get divorced, the divorce decree says, hey, we split up assets, you keep your IRA, but you never take your ex-spouse off of it. 37 states will get rid of that ex-spouse off the beneficiary designation. 13 states, though, however, say, hey, if you left them on there, it will pass to your ex-spouse. Think about how upset your current spouse is. Now, where this is a bigger problem, though, is in the 401k and qualified plan world. Why? Because this falls under ERISA. And in ERISA, we have a preemption statute, which says that federal law preempts state law. So these 37 states that say, let's ignore this ex-spouse as the beneficiary, these laws mean absolutely nothing to the 401k. The general rule is if you leave your ex-spouse on your 401k as your beneficiary and you die, guess what happens? Your ex-spouse gets those assets. And that is a huge issue. This could be the majority of an individual's net worth is tied up in their 401k. They pass away, never got around to updating that beneficiary designation, going to somebody that they really did not mean for it to go to. Companies, however, can have in their plan documents a clause, a provision that does allow to remove an ex-spouse when they weren't meant to stay on the plan beneficiary designation anymore. But I'd actually say it's not super common, but it is allowable. So that is one thing that pops up. So this one to me, anytime we're going through divorces, we're dealing with people who have been divorced, this is a very important thing to review. These cases have risen all the way to the Supreme Court, and the Supreme Court has upheld this, that the ex-spouse is entitled to it. I will make one more comment before moving off of this one. If you had a divorce decree, though, that did say you were relinquishing the rights to ERISA-covered plans, and then you just never updated the beneficiary designation, creates a very interesting situation in which where the benefits are still under federal law entitled to the ex-spouse. However, as the ex-spouse, there is probably a breach of contract claim that could be made against you in the same amount. So in those cases, you might want to look at a qualified disclaimer because otherwise you could be sued and easily lose the equivalent value in a breach of contract claim. So can get very, very, very messy here. So this goes back to proper ownership, proper transfer, proper review. Understanding this particular area is super important. While I don't have it on the slide, this does also apply to federal government provided life insurance. It's risen up in court cases before too, because again, same federal preemption statute kicks in there. So really, really important topic. Hopefully we're not running into the bad side of it, but something as we look at this tax and wealth and estate planning needs to be squarely within our vision. So let's talk a little bit here now about this digital asset world. So I'm going to use this quick story here up at the front, right? You have this dad here, and I guess on my left hand, I don't know if this is reversed. I guess that's how most people see screen, right? It's going to be on the left. So left-hand side, right? This father running a successful art store. His son says, hey, let me help dad run this business, get it all set up, gets the digital storefront done, launches the website, takes over the social media. They move from taking cash in the store to online bill pay, order tracking, everything in the store goes up online, right? And, great. Dad shuts down the storefront, has moved his art store online, doesn't need expensive real estate anymore, increased sales, reduced costs, more profit, great success. This little photo is completely AI generated too, just so you know. But then what happens, right? Son tragically passes away. Again, AI generated photo. I think he has one extra finger there too, just to make sure it's perfect AI. And her hands kind of blend together. So this is quickly disappearing, but still kind of exists today. Son passes away, right? Super tragic. Well, what happened? The son was the only one that knew the access to the email, the online systems, the website, all of it. And what did the son do? He just put it all in his own name because he just wanted to help his dad get all this stuff up and running. Father reaches out to all the service providers, but they can't help him. Why? Because he does not own any of these accounts, right? All of a sudden, this store is essentially, right, shut down. They can't do anything, can't operate any of the things that he wanted to operate, right? And even if he can go make a claim in court, this could take years to get access to these, or he'd have to spin up all new things. Incredibly, incredibly challenging situation. And this happens, right? This happens at single person risk inside small companies where one person manages all the tech, ends up sick in the hospital, can't work, right? Can't move the business forward. This is a bigger problem when it's like this, right? When it's named in somebody who is not the business. So this starts to build this modern day complication around digital assets and estate planning. While there's a lot of really cool things that are occurring in the digitalization of our world, there's ownership issues we've never dealt with before. There's control issues, there's distribution issues that we have never dealt with before as a society until relatively recently. Our assets and storefronts have only been online for a couple decades. We had storefronts for thousands and thousands of years. We know how to transfer those, but we're not as good at transferring digital assets yet. And so, again, this goes back to some of the research we did, but what you see here today is high net worth individuals have digital assets all across the place. 27% of a national survey of Americans say they have online business accounts at this point. 27%. That's a huge number. That goes back to the story we just said, but financial assets, over half of Americans, financial information, websites, photos, all of these things. We've moved our traditional world online. That's where we live today. All of you are on a webinar right now watching something that used to be done in person, right? And how do we deal with all this complexity moving forward? The other really, really interesting thing, and this was actually the purpose of the survey, there was a McAfee survey done back in 2012 that said it was about, I think, $74,000, $78,000 of digital asset value stored online per American. This survey actually found it's probably closer to $191,000. Now, this is a self-valuation of what kind of you would pay if you lost all of your digital assets, how much kind of like damage would that cause you, your photos, your websites, access to your online bank accounts, all those things added up together. The interesting part here, though, was the biggest driver, hands down by far, nothing else closed, was business owners, right? Business owners, actually 20% of them said that they had more than $300,000 in online business value from their firms. That is a tremendous amount. And we are doing very, very, very little to manage these today. Now, this does include things like crypto and those things. So that does fall in here. But when we talk about digital assets, that's actually a relatively small portion of our digital assets. It's our email, it's our websites, our social media, it's our photos online. It's all of those things that get added up together becomes our digital assets. So how do we protect these, and are people protecting them? Interestingly enough, I don't know that this is super important, but people do find that protecting their online assets is important. They actually said that was more important than having the appropriate amount of life insurance or having an up-to-date estate plan, that protecting your digital footprint rose to a level more important than that. I think it makes sense to me that we live so much in this digital world that it's going to matter a lot to people. And I think online theft and fraud is continuing to increase at a rapid rate, that people are concerned about this, especially if we believe we have on average about $200,000 of value online, that protecting this is going to be really, really important. But in general, it's not happening today. So when you go back and dive into it further, I think the top number is the only one I'm going to hit, and then I'll move off of this one. But only about 9% of Americans have an estate plan in place covering digital assets. So less than 1 out of 10. It is pretty small. One of the big reasons is there was a law passed kind of starting in 2016 called RUFADA, the Revised Uniform Fiduciary Access to Digital Asset Act, right? It rolls right off the tongue, super nice and easy. That model legislation ended up getting passed in 48 of 50 states, or some variation of it, I should say. And that really set forth the first time that we had state laws governing what happens to digital assets at the time we pass away. So we don't have great controls and mechanisms, and this is only 9 years old for the first law really being passed. Now, they kind of trickled in then to 2021 till we got kind of this broader coverage. But what that law says is to pass your digital assets over to your fiduciary, your trustee, your executor, you actually have to list in your will, trust, power of attorney document digital assets by name. So you have to use that terminology, that my digital assets will pass to my executor for his management or her management. We can't say all assets. All assets do not cover digital assets under RUFADA. So that is a super interesting thing that people tell me all the time. Oh no, my estate plan covers everything. I read it, no mention of digital assets, does not cover it in 48 out of 50 states. So that is a huge problem. So almost every single trust, will, power of attorney that was done prior to 2016 is immediately out of date today. So when you look at that, if you have clients that haven't updated their documents in more than a decade, they are not up and compliant today. In most states, this is actually an ethical violation for not including it as an attorney in the will and trust documents. That actually, under RUFADA, there is an ethics requirement of prudency for an attorney to discuss and incorporate this if needed. So that side, it is starting to gain traction, but still something that we definitely have to pay attention to. But here's the challenge, right? 2/3 of Americans have never heard about digital estate planning. It is not a concept that people are aware of, so we're not going to do it very well, right? If you look at it, the group that says they're knowledgeable in it's only about what is that one? I've got the little thing. It's about 15%. And about 8% of people actually, not 8, 9% actually have this in effect. So that tracks to me, right? It makes a lot of sense. So what do we need to do? The first part is we need to update legal documents. Like if they have not done this in a decade, we need to go look. What digital assets do we have? Which ones are important? Are there online tools that are available to help us with the management of these? If the assets are super important, do we understand what the terms of service agreements say with that provider? So Microsoft is a good example. A lot of people play Microsoft games. And if you read their terms of service agreement, uploaded credits into those gaming systems are lifetime leases and you lose those upon death. Apple, if you upload Apple credits into the Apple iTunes store, those are non-transferable. They end at the end of your life. Most of our terms of service agreements, that click-through agreement, right? When we go to sign up for something, and it says scroll to the bottom before you hit I accept, that we scroll to the bottom of as fast as humanly possible, that none of us have ever read any of them. Almost in all of them, they say that your online account is a non-transferable lifetime lease, and your right to use that account terminates upon your death. You cannot leave your online accounts basically to anyone. We can't change that with our trust or will documents. That is a contractual agreement that we have. But what we can do is give our fiduciaries the right to manage and wrap up these assets, right, upon our death or incapacity. We can't change ownership, but we can change the ability for them to manage it by putting it into the document. So please, if you take any one thing out of this, it should be knowing that these should be in our legal documents moving forward. Now, if you're working with good attorneys, they will be in there at this point, but it really does have to be added. So for anything over a decade, and realistically anything over like 6 years, is likely out of date and will not cover these assets. So that's a lot in the first part. I've got a couple more topics. They're a little shorter, but I think really interesting topics that are worthwhile touching on. So IRAs and state income taxes. So I think most people are up to speed, especially I know with some of the other presenters and using Holistic Plan. We're not going to spend time on really understanding these distribution rules, but most people are aware, right? IRAs after Secure Act and Secure Act 2.0, we got different RMD rules, we got different distribution rules to inherited accounts, but non-spousal accounts, generally speaking, we have this 10-year distribution rule. And that changed planning here a lot. Strategically, how do we spread out taxes over time? How do we maximize what we transfer to our heirs, our children, our grandchildren, our spouses? But generally speaking, when somebody inherits a traditional IRA, after we pass away, the distributions from that IRA are going to be subject, right? State income taxes and federal ordinary income taxes at the time they're distributed from the IRA. That's the general rule we need to know, that these are taxable. There is almost nothing we can do about the federal one, right? That it is what it is. We can't move to a different state and get out of federal taxes. From a state income tax perspective, though, that is a little bit different. If we have a kid that lives in a lower tax state, we could leave them the assets and they pay less in taxes. Something that has started to pop up in popularity here, though, has actually been using a non-grantor trust in a couple different states as beneficiaries that can still qualify for the 10-year stretch and can be accumulation trust, keeping the distributions and essentially, trapping, I put that in air quotes because it's not really trapped, but trapping those distributions inside of the trust as an accumulation trust. They can reinvest them to avoid state income taxes. Which I guess avoid isn't probably the correct word here, although that is what is occurring. It's more probably deferring out state income taxes, depending on what happens later on, because eventually if you want to take the money out, or we might deal with the same issue, but to at least defer those. So where we have beneficiaries in very high tax states, say like California, New York, New Jersey, it could make a lot of sense to actually use this strategy. Typically, two states are used here, either Delaware, as long as they're non-Delaware residents, and Nevada, because both of them have very favorable trust rules that allow for this and allow for the direction of investment advice to a third-party manager, and don't have state income taxes. So you're actually able to drop these in here, have the distributions come out. You will pay federal income taxes, no state income taxes until the money is distributed from the IRA. So to kind of spread out this tax challenge over time to defer some state income taxes can be a really effective strategy today for high worth IRAs for beneficiaries that are probably high earners in high income tax states. So I still don't see this used a lot, but it is something that needs to come back into the fold here as a conversation piece. So I think it's worthwhile if you've never looked at it. There are a number of companies that help kind of operate this from a trustee perspective. You do need a trustee in those states in order to be able to do this. So that's kind of, those two states are very preferential ones. Some of the other income tax states don't have good trust rules and trust laws, so they're not favorable for this. But really, this is landing in Nevada and Delaware today. But really interesting planning opportunity to kind of reduce down these state income taxes. But it's always worth the caveat, right? If you're living in New Jersey and then eventually take all the money out of the IRA in 15 years, New Jersey is going to tax you likely on that distribution from the trust at that time at the state level. So it doesn't necessarily, I said that avoid, it's not necessarily a permanent avoidance. But then if you move to Texas at some point, retired, and then could take the money out of the trust, you actually would have avoided it. And so it's a very interesting, and we're seeing more and more of these out there today. So next one here, Kratz and Krutz, similar strategy here. This actually was talked a lot right after Secure Act and Secure Act 2.0. And then I always notice these things pop up, they're interesting, and then start to drop down. I see Julie raised her hand. I don't know if I should be paying attention to things on the screen or not. So got a couple hand raised. Probably as good a time as any to take a pause, and so did I just answer questions? Is that good? We got more hands raised.
Yeah, we've got some, if you look at the Q&A tab, people
right.
can send your questions there, so that Jamie and the rest of us can take a look at them and get them answered.
All right, let's see what we have here. What's considered a small state? So that's a very good question. So that is going to actually be county by county. A lot of times it's like under 100,000. So that's a good one. But you do have to check with that county. It is not a state by state. So there's small probate proceedings, and different areas will have different amounts. But it does tend to be small. Not thinking like under $1 million as a small account, but like under 50, under 20, under 10, under 100. That typically is more of your range. So great question. Next one here. Can you go over listing minors in 401k retirement plans, best practices? Generally speaking, we should not list minors as direct beneficiaries of accounts. That's actually going to be the best practice. There's a lot of complexity that comes with it because they cannot take over that account at that point. So somebody else is still going to have to be appointed. So typically, that is where we would have, right, a trust or some other type of beneficiary there As the kids get older, though, a lot of times it actually makes sense to remove that trustee or trust vehicle from the ownership structure, because at that point, we really could split it up across multiple people. So that's a good one, too. Let's see what we have here. We had a lot of questions. Uh, please. Oh yeah, that's a good one. So this is a great, Steve, great suggestion. Steve was actually saying, put together kind of an explanation piece library for advisors pull off the shelf, and help communicate some of these. Can I list the 13 the spousal states? If you Google this one, there are some charts out there. I do not remember the 13 off the top of my head. But if you, yeah, I could, I think there was an article within the last, I will say, year, in Trust and Estate Journal, by Hoyt, who actually has a list at the end of the article. So if you kind of probably search like IRA, ex-spouse, beneficiary, trust and estate journal, there is an article by Hoyt that has a reference to this at the end of it. So that's actually a fairly specific, you know, way to point you to that one, since a couple people asked that one. Actually, that's kind of three people there. Digital assets when only one owner is allowed on the account. This is a great question. So most digital assets actually are only going to allow one owner on the account. So if you think about digital assets, it's mostly a online account, right? Like that's the short answer. You have one owner because one owner ties to one entrance point into the account, right? So your username is your global ID tag for your ownership of that service, is the short way to say it. But this gets to the other point. It is really super unlikely that when you get any type of online account, that the actual account itself you own outside of a lifetime lease, that you can use it for a period of time. They can cancel it, but even if you die, you don't own the account. So mentally, we have to think about like Gmail, right? My Google account, I do not own. I have a legal copyright ownership of the emails I've drafted that sit underneath of there. But I do not own the email and I do not own the account. But I have a copyright ownership to the emails I have drafted. Now, are my copyright emails super valuable in and of themselves? Not really. But actually, Rufata even goes so far to say that they don't need to pass over your emails to you, but just a listing of all the stuff you have in there. Oddly enough, they don't actually have to give you access to your email in and of itself. Now, some of those ones, Google, Facebook, I think LinkedIn just added, have the equivalent of a beneficiary designation that you can now add. So if you go into Facebook, you can actually set it so it memorializes you upon your death. You can do the same thing with Google, which will actually, at a period of not, I guess, inactivity, you can set it so it passes your email and login to a different account. So essentially, right, you become inactive for 3 months, something happened to you, it will kick that over to a different person to be able to go in and manage. But remember, keep that like differentiation in your mind. Ownership of the assets and access to them are very, very different things. So that's a super fine line here, but very important. So like Coinbase, I'll hit this one and then I'll keep moving on. Coinbase, if you looked at, I haven't looked at the agreement as of recent. It's probably been 2 years. But my original Coinbase agreement actually said that if something happened to me, my heirs, my beneficiaries, nobody could have my Coinbase account. So that's a really interesting one, right? Because I have a valuable asset inside of there, right? Bitcoin, but I have no right to enter the account. So that becomes that situation that if you do not put that in your trust and will documents, your fiduciary has no right to go in there to get out the value. So that is where this planning becomes super, super important. All right. 1,000 people can ask a lot of questions. Should I just keep going through these? I don't know. People also raise their hands, they keep presenting, but it's going to take me a bit to hit all these. What do people usually do, Kate and Lana? You want me
Yeah,
to
you're
go
welcome
on?
to keep going, Jamie. We'll have, the Q&A will stay up, so those questions aren't going anywhere.
All right. All right.
We
I will
can
go for a
follow up
little
on people
longer.
later.
We knocked out a couple.
Thank you for answering those. Yeah, that was great.
Yeah. Yeah, I'll come back if I get to more of these. But and am I till 2 o'clock exactly? Is that my time?
Yep.
11 minutes? All right. All right, let's try to hit a couple more. I'll try to get back here. So crats and cruts, super important topic. So crats and cruts are two different versions of charitable remainder trusts. So a charitable remainder annuity trust and a charitable remainder unit trust. A crat is essentially a fixed percentage, 4% of $1 million trust, pays out 40 grand a year, every year, till it runs out of money, basically. A crut says, hey, 4%. But we're going to revalue the account each year. So year one, it's $1 million, and it's 40,000. The next year, market tanks, and it's 500,000. Well, now we pay out 20,000. So it's going to revalue. So CRUTs and CRATs are actually very unique vehicles to be considered as potential beneficiaries of IRAs and retirement accounts. So the first thing, though, is if your if your client has absolutely zero charitable intent, this is likely not a good strategy. However, if your client says, I want to leave something to a charity, and you see that they have a large IRA or 401k that's going to become an IRA, this is a worthwhile conversation. It was not as big of a conversation when we could stretch out IRA distributions over the course of somebody's life. But since we went to mostly that 10-year rule, this has actually become to the point where in some situations, we can leave more money to our beneficiary than we could with a traditional 10-year IRA distribution. And when we combine the amount that goes to both the charity and the individual, actually in most situations, it will beat out the total amount of money that is being passed over to like our kids as the beneficiary. Now you say, how does that happen? Well, essentially what happens is if we leave the IRA to a charitable remainder trust, right? And the IRA goes there, it's distributed out, but it is not taxed at that point. So the whole $1 million sits in the charitable remainder trust. It gets invested and it starts paying out that payment, whether it's a CRUT or a CRAT. You can have it pay for 20 years as a fixed time period or for the life of the beneficiary. And then the remainder, whatever's left over in there, then goes to the charity income tax free at that time. So as the individual gets payments out, they will pay taxes in a similar fashion, although there is an ordering of this too, right? Where you get, the kind of tax deferred money, ordinary income, all the way to capital gains as it distributes across the timeline. Mostly just think about it as ordinary income to the income beneficiary. Then the remainder goes to the charity tax free. The other thing we get is we can now spread this out over 30 years. So we can almost mimic the traditional IRA stretch by using a charitable remainder annuity trust or CRUT. So we can get a 35-year payout time period. So we're able to spread out that tax hit. We're able to defer taxes for a longer period of time. For the amount that is expected to go to the charity, we get an estate tax deduction if that's important. But that number's so high today, as you see, I really don't talk about it a lot, especially after the new bills going up even further, not impacting most of our clients. We get continued tax deferred growth and potential tax mitigation. When you layer all those things in, what you start to see is a little bit of this. So this is one of my good friends, Bob Keebler's been doing this analysis for years now. But this is actually some of his analysis. And what this is showing is if you look at, and it should make general good sense, that if you have an immediate distribution of a $1 million IRA and you pay 40% taxes, you're going to have the least amount of money because you pay this huge tax hit up front. And then a 5-year distribution period for qualified assets, you're going to have the next least amount because you have the least amount of tax deferral. The next one is going to be the 10-year. So those are the bottom three lines, that red, orange, and I don't know, neon-ish blue line. Turquoise, I don't know. Everybody probably sees that one different on their computer. But the bottom three lines all make sense in conjunction to each other. Now, the lines that go above it, the important thing about those four are that they're all just different versions of charitable remainder trusts. But across the entire spectrum, even if the individual only lives for 1 year, they will pass more money net of taxes to the beneficiary and charity across the entire spectrum of the potential 30-year time period. There is no year and no situation in which the combined amount will be less. Why? Because whatever goes to the charity here, right, even if it's after year one, will go income tax free, right, to the charity. So if the client is okay with passing this over, they will do very well leaving this net benefit to a combined split beneficiary designation. So to me, this is a very powerful strategy. Now, going back to the other point, if you do care about your heirs getting the majority of the money, this is not necessarily the best, right? They die in year one, they get like 40 grand of your $1 million and 960,000 goes to charity. So if that's not an outcome you would be okay with, it doesn't work. But from a pure tax deferral, tax mitigation, and total transfer perspective, this is much more able to, imitate the traditional stretch IRA than any other feature out there today, outside of some life insurance strategies get similar. I will do this one, and then I'm going to call it quits on this, and maybe I can answer one more question. So we often talk about HSAs, and HSAs are a great savings vehicle, right? We get tax-deducted contributions. We're in the high deductible plan, tax-free growth as long as they are tax-deferred growth, and then tax-free growth for qualified expenses. One of the big challenges with these, though, becomes what happens at death. What happens when you die owning an HSA? If it goes to your spouse, there is really no complication. They can treat it like their own. From a tax perspective, nothing really changes. For non-spousal beneficiaries, though, this is a huge one and is still not talked about enough today. It becomes fully taxable in that year that they inherited. You can, however, pay for expenses of the deceased owner within 12 months of the owner dying, and they will reduce that tax liability. So if they have really high medical expenses when they pass away, you might be able to deplete this thing down, pay it via here. There is no step up in basis of this asset at death, so it's fully taxable at that point. The other thing that's important is, let's say the owner was not using their HSA and accumulating those medical receipts their whole life and storing them and say, one day I'm going to take all the money out and get it. Those you can't use. They actually have to be expenses that you pay within that 12-month window to offset the taxes. So it's a little bit of a nuance here, but a really, really important one is HSAs continue to grow. We continue to save in them. We do have to understand a strategy to deal with these. If we get these large HSAs in the next decade and somebody passes away, how do we deal with this? Right? Making sure that we are covering those, end of life costs here. Definitely important. So I'm going to stop there because I'm pretty much out of time. I only had 2 more topics anyway. Yeah, do you want me to answer 1 or 2 more questions? Or I can kind of say thank you and start wrapping up too.
Yeah, feel free to maybe answer one more question in the chat, and then we've got about 2 minutes and we can tie it up there.
Yeah. Okay. A couple of these, a couple of the quick one is Bitcoin part of the digital estate planning? Absolutely. Crypto are digital assets and need to be planned for in the same way. Would access to a password vault where all account username help access to the others? Also, this is fairly nuanced one. Practically speaking, yes, having access to the usernames and passwords would give you access, right? It's having the keys. If you have the keys to the house, you can go inside the house. Legally, though, you might actually not have legal rights to access those. And technically, if you're using a password or username that you don't have a legal right to, is a breach of federal law. While like technically, yes, if I had Kate's username and password, can I log in as Kate? Yes, but I'm impersonating Kate. I don't have a legal right to access those. Your terms of service agreements almost all say you can't give your username or passwords to anybody else too. So like that's actually in there. So the correct thing to do is to keep a list of those, but also to have it still listed in the documents that this fiduciary has a right to it. So that's a good one.
Awesome. Thank you so much, Jamie, for your time today. You were managed to have a super big presentation and answer a lot of questions. That's a lot to conquer in an hour.
Yeah.
But we're really thankful for having you on the call. And we are going to share, yeah, Jamie's slides with you guys. So if you have questions, we'll have those slides available for you. Feel free to give Jamie a shout out in the Q&A. I know that, we had a lot of good things to take in this presentation. So feel free to share something you learned. And we're gonna go for another short break, but don't worry, we'll be right back. We're gonna have Debbie Taylor come on in just a few minutes.
Well, thank you, everyone. Thanks, everybody, for listening. I know there was a lot of questions. I'm happy to take some of them. If you want to share my email or you want me to, or LinkedIn is an easy way to find me too on LinkedIn. Is totally fine with me.
Yeah, we'll do a little follow-up. Jamie, I'll share the questions with you after the fact, and then we'll include some answers in our follow-up emails for this. So you guys will get your
And
questions answered for
and if
sure.
Debbie's on here now, Debbie, do a great job. Love you. Always does an amazing job for you all and everyone. So thank you, everyone. Have a blessed day.
Well, thanks so much, Jamie. We'll be right back, everybody.